In a medical malpractice case here in New York, if I get the doctor that you have sued to admit that he violated the basic standards of medical care during his pretrial testimony, can I use that information at trial? Would you like to know the answer? Come join me for a moment as I show you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. The answer is absolutely I can use that. When I question a doctor during his pretrial question and answer session known as a deposition, that is the same as if I'm asking him questions at trial. It carries the same exact weight. He is swearing to tell the truth. The questions that I am asking and the answers that he is giving to me are now recorded by a court stenographer, a court reporter, during the course of this question and answer session in his attorney's office. So if I am able to get the doctor to admit and to accept the fact that if he did certain things, that not doing A, B, and C, for example, would be a violation from the basic standards of medical care, and he answers me affirmatively, yes, that would be a violation from the basic standard of care, now at the time of trial, I can then use that at trial to show to the jury that this doctor was careless, that he was negligent. And then I can use that with my own expert to now confirm the fact that there was wrongdoing in this case, and that wrongdoing caused injury. And now we can go ahead and explain what those injuries are. And I can also use that when the defense's medical expert gets up to testify and showing him that under these circumstances, the doctor who we have sued confirms and admits that he violated the basic standards of medical care. Now, how do I get him to do that? Well, I do that by using something called hypothetical questions. Doctor, I want you to assume that on this day, the patient presented with the following complaints. Would you agree that in that instance, it would be important for you to do the following things? Yes or no? And now he's going to tell me. And would you agree, doctor, that failing to do those specific things would be a violation from the basic standards of medical care? Yes or no? The law allows me to ask the doctor hypothetical questions based upon those set of facts that we believe to be more likely true than not true. And by the way, I'm not going to stop at just one question. And doctor, would you agree that a doctor who fails to do those things, that now this patient can and will suffer the following injury? And now he's got to go ahead and tell me yes or no, or he doesn't know. So why do I share this great information with you? I share it with you just to give you some insight and a behind-the-scenes look at what goes on in these medical malpractice cases here in New York. You know, I recognize you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need to be answered first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.